The First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Good afternoon. We have two cases scheduled for oral argument this afternoon. Our first case is Roxanne Walls and Skylar Thomas et al. Versus Partners for Pete Incorporated et al. We have allocated 15 minutes per side for the oral argument. Mr. Howell, would you like to reserve some time for rebuttal?
Yes, Your Honor, 2 minutes.
So noted. You may proceed.
May it please the court. I am here today on an appeal from a summary judgment ruling from the trial court involving the interpretation of an insurance contract, and therefore we're here on de novo review. As I mentioned, I represent Roxanne Walls and Skylar Thomas as the personal representatives of the estate of Rachel Walls. This case involves a fatal motor vehicle accident that occurred in March of 2018. Accident was caused by a Madison Chafin who was in the course and scope of her employment for Partners for Pets. Chafin was driving a Mustang owned by her parents that was insured under a Geico policy with $25,000 of coverage. Geico paid its limits in exchange for a release of just the Chafins, and that was in the record. Likewise, we have a claim against Partners for Pets. The only policy that Partners for Pets had was a commercial general liability policy with Southern Owners, which included an endorsement that provided coverage for non-owned hired autos, which would include this vehicle we have here today that the Chafins were that Miss Chafin was driving.
Excuse me, the counsel. The amount of the policy with Southern Owners was for how much?
$1 million, Your Honor.
Okay, so the judgment's $5 million. There's $1 million policy out there, and Geico paid, what was it? You say 30? Was it
25,000, Your Honor?
But the Geico policy was not held by Partners for Pets. It was held by the individuals, right?
It was an individual family policy purchased by the Chafins, Miss Madison's parents.
So how was that policy available to your client? I mean, it was available to the Chafins.
That's argument number one, Your Honor, is that was not available to Partners for Pets. It was available.
The funds that were paid pursuant to that policy became available to be used to satisfy part of the judgment.
Correct. To my clients, the Walls, the estate of the Walls, but not to Partners for Pets, who was the insured and the named insured under the policy.
But if the policy here, if the exclusion said if you do not have any other insurance proceeds available, right? In other words, the insurance wasn't made available to your client, but the insurance proceeds were.
Correct.
Okay, I got it. Thank you.
Right, to my client, correct. So the reason why this judgment should be reversed is because first, there was no other insurance available for Partners for Pets, which was the insured under the Southern Owners policy and the defined named party. This was admitted in the affidavits that were part of the summary judgment record from both Southern Owners, Geico, and Partners for Pets, which all confirmed the only policy providing coverage for Partners for Pets was the Southern Owners policy.
Counsel, let me ask you a question about the availability issue. So it seems to me that you're drawing a distinction between a practical availability, meaning that the money is gone, and a difference between that and legal availability, whether or not the entity was covered in the first place. Am I right about that? Are you defining availability in a particular way?
Yes, Your Honor. First, the policy was not available to Partners for Pets for a couple of reasons. First, there was an exclusion in the policy for whenever someone was carrying property for compensation or a fee. That was an exclusion in that Geico policy, which would have eliminated coverage for.
Well, since you raised that, let me just ask you about that while you're on it. Is there some record evidence that you can point to for us that demonstrates that Chafin was receiving compensation or payment?
What we had was record evidence that she was in the scope and course of her employment, and the trial court order even confirmed that she was in the scope and course of her employment. Therefore, that at least creates an issue of fact of whether or not she was receiving compensation for that, which was actually conceded in some of the argument that there may need to be some discovery on that. But the judge simply did not go down that path based off of what I said was a logical fallacy that because Geico paid, there must be coverage was what the judge ultimately determined. My position on that is well, if that was true, then the fact that Southern Owners hasn't paid means there's not coverage. You have to look at the actual policy itself and the facts that are in play.
So your position with regard to compensation is that there's a disputed material fact issue.
Correct.
You contend that she was receiving some compensation, and we can hear from Mr. Shoemaker, I guess, about what the way he'll address that. But the record evidence, anyways, that you're relying on is what?
There was an affidavit from Southern Owners that confirmed, as part of its analysis, that Madison Chapin was in the scope and course of her employment for Partners for Pets, which was cited in the brief and was part of the ultimate order that the judge rendered that confirmed that he found that she was in the scope and course of her employment.
And so being in the scope of employment, there's this issue about there being volunteers, that they're run by volunteers, right? So your position is that by being in the scope of employment that you think that infers some payment or compensation.
That does
not that she was volunteered.
Correct, Your Honor. That creates an issue.
Did you argue this point below?
Yes, Your Honor. Yes, Your Honor. It was argued in the briefs below, and it was also argued specifically before the court, and it was addressed in the order itself. But the other issue, once you get past whether or not there was actually available coverage to Partners for Pets under the Geico policy, is was this a same or similar policy? And we have had a couple of courts that have addressed this issue. And in fact, there's three. Two of the three that have addressed it have found that there would be coverage under similar circumstances. The first,
in terms of the courts addressing this issue, the trial court, as well as counsel for the appellee, relies on the 11th Circuit case of Southern Owners Insurance Company versus Eastern Roads and Associates, which is a 2017 case. Can you distinguish this case?
Yes, Your Honor. The case of Southern Owners versus Eastern Roads, it followed only 2 years after the court had actually come to an opposite conclusion in the wall-to-walls decision. And in that decision, the court specifically noted that in Eastern Roads, they noted that there were two possible definitions for coverage. One that would simply limit it to specific risks in an insurance policy, and a more broader definition that would look at the overall scope of the protection. Unfortunately, in the Eastern Roads case, they decided to go with the narrow definition instead of the broader definition that the court had used in walls to walls, and by implication also used in the Auto Owners versus Benjamin, which was the South Carolina case that I cited. And what happened is the Southern Owners versus Eastern Roads case is not applying Florida law appropriately to ambiguities and language used by an insurance company, because all of the tools of construction work towards, if there's any sort of ambiguity, we go toward liberal construction and allowing defined coverage for the insured. And if they had used the broader definition of coverage, which looks at the scope of risk covered by the policy, you would clearly find that there should be coverage for this, because the two policies would not be looked at in any way and seen to be the same.
Assuming for the sake of argument that we agree with your position, how do you propose we deal with the Southern Owners Insurance Company case?
The Eastern Roads case, Your Honor?
That is correct. Yeah.
Well, what's similar to what's been done in some of the other more recent cases where, for example, I cited the bad faith case, the Harvey case, that where federal courts have not been taking and interpreting the precedents of Florida cases on some of these insurance issues consistent with the precedent of Florida law. I believe that obviously the federal court case isn't binding, and we have is for this court to decide this is a matter of first impression. And I believe the court should simply find that the walls to wall in the auto owners versus Benjamin case are more consistent, or are consistent with the way Florida courts deal with interpretation issues. And we should have gone in the Easton Roads case with the broader definition of coverage, which is all the scope of the risk covered by the policy. And then you would say that these two policies, similar to what the walls to wall decision did, which went through a whole table of analyses of the distinctions between the two policies, different named insureds, different covered vehicles, different amounts of coverage. Both of those cases noted the vastly amounts and the differences in coverages in order to show that that's not what a reasonable person looking at those two policies would say they were same or similar. And all of this language seems to be popping up in auto owners or Southern owners at sister company cases, and they've been put on notice specifically in the South Carolina case, the Benjamin case, that if they really wanted it to be construed the way the Easton Roads case ultimately did, they could have corrected the language and made it a lot more tailored and say simply if any other policy is available whatsoever. And they could have done that. They have not done that. So there are reasonable interpretations that lead to a result where this is not, the coverage is the whole scope of risk of the policies, and they are not the same and cannot be reconciled, so that there should be coverage, because it's especially true when you're dealing with an exclusionary provision like is being asserted in this escape clause. The heightened ambiguities and construction in favor of an insured in order to find coverage is most apt, because you're dealing with a situation now where Partners for Pets has absolutely no coverage in the underlying wrongful death case because the Geico policy was not available to it. And Southern owners has now refused to defend or indemnify them. So they have absolutely no coverage available for them. And that's why they bought this policy, was to allow that.
Let me ask you a question. I'm sorry. Go ahead, Judge Makar.
Well, quick, I'll try to make it quick. But for the serendipity of the father's policy, the Geico policy, wouldn't Southern owners be paying today?
Yes, Your Honor. If there were, if I don't think they would have any argument if there was no policy whatsoever. They're relying solely on the existence of the $25,000 Chafin policy.
Thank you.
So my question, I want to go back just a bit to the availability, and I think your argument, at least to some extent, turns on this issue. So you have $25,000 that's paid out from the Geico policy. Your position is that if the other policy has been exhausted, that it is not available to you.
That is correct, Your Honor. And it's also consistent with the other insurance provision that is in the policy, the base Southern owners policy, which the CGL endorsement incorporates all other terms of the policy, which includes the other insurance provision, which would provide that this would be excess once any other policy has been exhausted. And that's my final argument on that, as well, is that there's the Travelers versus Lexington case that holds when you have an escape clause and an excess clause like this, where one says if there's other insurance, then there's no availability, versus if there's others, it's excess. Those two provisions cannot be reconciled, and you have to eliminate them and provide coverage. And I'll hold my rest.
Counsel, you are into your rebuttal time.
Yes, Your Honor.
Mr. Shoemaker, you may proceed.
Thank you. May it please the court. And I represent Southern owners on this case. I just want to start out with talking about the Southern owners policy itself. It was a commercial general liability policy. It was not an auto policy. That policy.
But counsel, if I'm sorry to interrupt, but it covers this auto accident, but for this language we're debating today, correct?
Actually, I don't believe it does, Your Honor, because when you look at it, it contains an endorsement that extends coverage only under certain circumstances. In other words,
were those addressed in the trial court's order?
I'm sorry,
Were those addressed in the trial court's order?
was the endorsement addressed?
No, what you're about to argue.
Yes, yeah, but, yeah, I mean, I argued this with the court.
Okay.
Is that coverage is excluded under the CGL policy pursuant to exclusion G, which excludes coverage for automobiles. It's only then added back into the policy under very limited circumstances pursuant to the plus endorsement contained in the auto owner's policy. That endorsement says that coverage for bodily injury and property damage under section 1 of the CGL is extended as follows under this item, but only if you do not have any other insurance available to you which affords the same or similar coverage. It doesn't say anything about whether or not if you have any other policy limits available to you. It doesn't say anything or discuss anywhere about whether the policy limits have been paid or the exhaustion of policy limits on the other insurance that's available that affords the same or similar coverage. And if you look back then at the GEICO policy, which is in, it's in the record as well, and where it lists persons insured, it says who is covered, and it covers the insureds, you, or any other person using the auto with your permission, or number 3, any other person or organization for his or her liability because of it, acts or omissions of an insured. So that basically by its policy, the GEICO policy covers an organization for its liability because of the acts of the GEICO insured, in this case, Madison Chafin. Partners for Pets was almost certainly an insured under the GEICO policy based on that language. What appellant wants to try to argue here today is that an exclusion to the policy, which was actually an amendment that added the exclusion, or at least changed it, which said that it's not available if the vehicle is being used for compensation or a fee. Well, unfortunately for the plaintiffs in this, or the appellants in this case, there, number 1, is no record evidence that Ms. Chafin was using the vehicle for compensation or a fee, only that she was, quote, employed by Partners for Pets.
Do you not think that being employed by Partners for Pets, that you could infer or it might imply that she's receiving some compensation?
Well, you might be able to imply it in normal circumstances, but I don't think you can imply that in a case where you're talking about basically a volunteer animal shelter organization that delivers pets. So
we're talking about whether or not there's for summary judgment purposes, whether or not there's a disputed material fact, right? And so
right.
If there's dispute about whether or not she's receiving compensation, that might be important here, right? So the question is, does the scope of employment, does an agreement that she is acting within the scope of employment, is that sufficient to create a disputed material fact?
I don't believe it does in this case, Your Honor, simply because of the fact that as an exclusion, it's up to the insurance carrier to basically prove that the exclusion applies or to apply the exclusion. In this case, GEICO didn't do it. GEICO went ahead and paid its policy limits in this case. Now, arguably they should have taken into account Partners for Pets' interest when they settled the claim, because Partners for Pets wasn't insured under this unless they wanted to apply that exclusion. But it's certainly unrefuted that GEICO paid its policy limits and basically accepted coverage in this case. And that's what we're talking about, whether or not there was.
Do you think GEICO's coverage determination binds the question here? Do you think that it resolves it just the way that, by virtue of the way they resolved the matter?
I think by them paying their policy limits and not asserting the exclusion that's now being asserted by the appellants, that GEICO has essentially admitted that there was coverage under its policy for this accident. That exclusion would have applied to Madison Chafin. It would have applied to her parents as the owner of the vehicle as well. That didn't just apply to this other organization that is an insured person. So
how do you deal with the availability argument that the policy wasn't available because it had been exhausted?
Looks like we lost him.
I think he might be frozen.
I guess he's not aware of that. Hopefully our technical folks can solve this problem shortly.
I'll see if I can call him. There he goes.
Ms. Shoemaker, are you there?
I am here. I apologize. Everybody froze and I,
Oh. You're back.
Judge, I wanted to try to respond to your question, but I don't recall exactly what it was. I think I heard just a portion of it.
All right, so if we're back on, it looked like you're kind of clicking back in and out, but if sounds like you're back on, so we'll just we can maybe pick up from where we left off. So my last question was I wanted to hear your response to the argument that the policy was not available because it had been exhausted. So that the money is paid out, it's no longer there, and so it is no longer, the language is available to you, right? So that the argument that it is no longer available to them because it's been fully paid.
Well, Judge, the argument is that the insurance was available to them. I mean, because they, because Partners for Pets wasn't insured under the policy. I mean, that money should have been paid for on behalf of all of Geico's insurers.
Well, that's my point, Counselor. I talked earlier about it. The point is that if it says you do not have any other insurance proceeds available to you, but it doesn't say that. The language in your client's contract, or policy, I should say, just talks about insurance. Well, insurance what? An insurance policy, insurance proceeds, insurance risk. I mean, it just says insurance.
It says insurance coverage.
No, it says insurance available to you, which affords same or similar coverage. It doesn't say insurance coverage.
Actually, Judge, and I don't mean to be disrespectful at all, but I'm looking at it on my other screen. The actual language of the Southern Owners Policy says that it is extended, but only if you do not have any other insurance available to you, which affords the same or similar coverage.
Right. We're looking at the same language.
Okay. And so the insurance available, which affords the same or similar coverage is.
Well, then I'm sorry to interrupt, but that would seem to suggest it cuts against your argument because the word insurance, in your view, then is insurance policy.
Well, I mean,
and the insurance policy was not available to Partners for Pets. It was available to the Chaffins.
Well, but our argument is it should have been available to Partners for Pets because they were insured under the policy. I mean, that doesn't, just because they pay their policy limits. I mean, then any insurance company could come in and pay us policy limits and say, now there's no more insurance available. I mean. Well,
Counselor, maybe if I could just throw this out as a thought and you can respond to it any way you want. I've got the judge's order in front of me. I thought the issue today was essentially a coverage issue. That's all the judge's order, I think, the order granting summary judgment talks about, is there coverage under this language, the language you and I just discussed. Isn't that the only issue before us?
Well, yeah, the only issue is the issue essentially from our standpoint is whether there's the same or similar coverage available to Partners for Pets under the Geico policy as there was under that CGL Plus endorsement, if in fact that endorsement then extended the coverage of the CGL policy. There was coverage available to Partners for Pets under the Geico policy because they were insured under the policy. And they were insured for bodily injury and property damage, the same as in the auto owners or Southern Owners policy.
Okay, so Geico would have provided a defense to Partners for Pets.
Yes, I mean they should have. I mean, there may be an issue or a case there that the appellants in this case can pursue, for Geico not, or that Partners for Pets can pursue for Geico not taking into account their responsibilities with regard to Partners for Pets. I mean, and there's still issues with regard to the purchase of the policy itself, which were stayed, pending the resolution of this case.
Well, let me ask you this. I put the language of the policy into Wessel and I turned up 8 cases and they're pretty much evenly divided. and none of them bind us. None of them bind us, okay? So it is, as your other counselor said, it is a case of first impression in Florida. We don't have to follow the most recent 11th Circuit case. We don't have to follow the previous 11th Circuit case. We don't have to follow Judge Hodges' order. We don't have to follow Judge Covington's order. So give us your best argument of which path we should follow here and why.
Judge, our argument essentially is that the Easton Roads case, which was initially decided by Judge Vincent and then was decided by, I think, a 3-judge panel of the 11th Circuit Court of Appeals, is, while not binding on the court, we believe it's pretty compelling, and because it talks about how you define coverages under the policy. And as the appellant's attorney said, I mean, if you take the approach, a broad approach that coverage talks about the whole realm of risk under a policy versus a specific risk covered under the policy, well, then yes. But as the court in the Easton Roads decided, you really, the better way to handle that is to look at the word coverage to mean the specific risk under the policy. And in this case, you've got you've really got the same coverages available, not just similar, because you've got the GEICO policy, which covers bodily injury and damage to property. It covers through the use of owned and non-owned vehicles. And then you've got the Southern Owners endorsement, if it extends the coverage, would cover bodily injury or property damage to use of a non-owned vehicle. So essentially, you've got the same coverage here. Under
okay. Well, given that the courts are divided on this issue, I mean, you've got a federal district judge in Tampa, federal district judge in Gainesville. Both are affirmed by the 11th Circuit, even though they came to exactly opposite results, although the cases perhaps could be distinguished. I'm not exactly sure. Doesn't it suggest that the language is susceptible of more than one reading if all these judges have divided on it, and so therefore there's an ambiguity, and therefore under Florida law it should go in favor of the insured? I mean, after all, y'all drafted this language.
The court in the Walls to Walls case entered an unpublished opinion, which was specifically addressed in the Easton Roads case.
Well, but like I said, nothing binds us. What we decide, what our panel will decide, is which approach is the most persuasive.
Right, and we believe that the Easton Roads case is the most persuasive, because what it did was it took it a step farther, and it basically says that when you're looking at an ambiguity and you're trying to see, okay, is the term similar ambiguous? And they said, well, standing on its own, it could be, but when you combine that with the word coverage, now you've limited it enough so that you can get a reasonable definition of what the policy is talking about. Similar coverage versus just the word similar. Coverage is under the policy when you define that as the narrow scope of the coverages that are being requested under the policy. In this case, bodily injury coverage. I mean, it's clear that you can really look at the policies and say, are these the same or are they similar? I mean, there is no ambiguity on that. And so we think that the better language, the better reasoning is contained in Easton Roads, because it addressed the other issues. It addressed the ambiguity issue. And the 11th Circuit essentially found that by taking into account the entirety of that provision, that it's insurance cover, similar insurance coverage, not just the word similar, it really is no longer ambiguous. So, I mean, we would argue that that's the more reasonable of the decisions, and we would ask the court to affirm the trial court's ruling.
So you're almost out of time, counsel. If I can just give you one quick thing to maybe see if we can wrap it up. I'd like to hear your explanation with regard to the potential conflict between the escape clause and the excess clauses and how they can be read together in the same contract.
Well, I believe they can easily be read together, because in this case, you've got a CGL policy which specifically excludes auto coverage, and the excess policy is part of that coverage form. The only way you get coverage added back in is through the endorsement, which extends coverage only under those limited circumstances. If you don't extend coverage, then there is no, the excess provision doesn't really apply because you're excluded under the auto exclusion. If you extend coverage under the endorsement, then yeah, it applies. Then we have to determine, okay, which was excess and which was primary, or are they pro rata, and do that. But that's not the situation I think we find ourselves in. So no, they're not mutually repugnant. I mean, when you consider the fact that coverage is only extended under those limited circumstances under the auto or Southern Owners policy, and it was not extended in this case, which is our argument, then you don't even get to the excess clause.
Counsel, one final question.
Yes, sir.
Has there been any other opinions from the 11th Circuit since Easton Rose on this issue?
Not that I'm aware of, Your Honor.
Thank you.
Thank you.
Mr. Howell?
Yes, Your Honor. Just to follow up on Judge Makar's issue on the first impression and the best path forward, I believe he hit the nail on the head. There's been a lot of judges that have looked at this, and that in and of itself, with the conflicting decisions, shows that reasonable minds can come to different conclusions and several judges have found that there were coverage under this language under very similar circumstances. And under the controlling Florida law principles on how to construe ambiguities, and especially when they're in exclusions against a drafter, it's important to remember auto owners, or Southern owners in this case, had the ability to control that language and draft it, and was on notice of that through all of these cases, hasn't changed that language. And a reasonable interpretation, as pointed out in the Easton Rose, there were two choices they had to go with the definition of coverage under the Black's Law Dictionary. They chose the narrow one. They could have equally chosen the broader one, which the other cases essentially went with, which was the total scopes of coverage under the policies, and determined that those are not same or similar. A reasonable insured looking at those would not think that those two policies were alike. And so therefore, under Florida law, this properly would have coverage for this unfortunate accident. And I would request that the judgment be reversed and an order entered finding coverage under the Southern Owners policy for the benefit of Partners for Pets and my clients ultimately.
Thank you, counsel, for your respective oral arguments. This includes our oral arguments in this case.
Thank you.
Thank you, Your Honor.
Good afternoon. Our second case scheduled for oral argument this afternoon is State Farm Insurance Company versus Norton. We've allocated 15 minutes per side for the oral argument. Mr. Samus, would you like to reserve some time for a rebuttal?
Yes, Your Honor. May I have 5 minutes, please?
So noted. You may proceed.
Thank you, Your Honor. May it please the court. My name is Scott Samus. I represent the appellant State Farm. We're asking the court today to reverse the order below that denied State Farm's motion to compel appraisal to resolve a property damage case. This is a fairly simple argument, or a very simple fact pattern. This was a plumbing loss, a pipe case. State Farm adjusted the claim, made a payment, sent a letter with the payment that explained what was covered, what was not covered, the deductible, and the initial payment. Also on the same date, which was August 15th, 2019, State Farm sent a Dfs Mediation Letter. That's the letter that's required by 627-7015 of the Florida statutes when there is a dispute over the amount of a claim, that letter goes out. In this case, since State Farm paid less than the amount of the total damage because it was partially non-covered, they sent the DFS mediation letter on that same date. Then about 6.5 months goes by and State Farm doesn't hear anything and they get a lawsuit. And the lawsuit essentially says, State Farm, you breached the contract because you did not pay us enough. And to be clear, State Farm did have the right to invoke appraisal. It had the right to invoke appraisal pre-suit and when the suit was filed. But there is no requirement to invoke appraisal at that point. When you have the right to appraisal, it is not a waiver to wait. And there are good reasons for that. Because when you make a payment on a claim, a partial payment on a claim, many times the insured will accept that payment, accept the explanation, and the claim is over. If the insured objects or presents additional information, many times there's additional adjustment and the case can be resolved without any kind of an adversarial proceeding. Also, the insured may request DFS mediation and the case can go to mediation and be resolved. So what happens is, in this case, is that none of those things happen. The insured decides to file a lawsuit. Now, at that point, State Farm had the right to invoke appraisal, but did not have to. No court has said that you have to invoke appraisal right at the outset of a lawsuit. In fact, there are many cases where there is a delay. The key question is, what did State Farm do during the pendency of the lawsuit, during the delay, before the appraisal demand, that was either consistent with appraisal or inconsistent with appraisal? And we would submit that what State Farm did in this case puts it in the category of cases where there was not a waiver of appraisal. And the key to understanding this is that the initial lawsuit was very vague. All it said was, you didn't pay us enough. Now, in cases like that, that can mean an entire spectrum of things. It could mean something as simple and easily resolved as, you didn't pay us for the corroded pipe, we think you should have paid us for that. Now, if that were the scope of the claim, it would make sense to send it to appraisal. The more efficient way to resolve it would probably be just to answer the complaint, do cross motions for summary judgment, and that would resolve it. The other possibility is that there is a wide range of disputes over amounts, how much of the house needed to be torn up, how many things needed to be resolved, needed to be repaired, how much was the repair cost? Was it more than State Farm allowed for the claim? Is there a need for additional living expense? Is there a need for ordinance and law coverage? State Farm didn't know. So what they did was they asked for a more definite statement. And in that motion for more definite statement, they said, one of the reasons is we want to see if this is something that should go to appraisal. So in that reaction, that substantive reaction to the lawsuit, they said, this is why we're asking. Now, in the 3.5 months that goes by after that, they don't do anything to force the action. All their involvement from that point on is entirely passive. They file a notice of appearance. There are requests for extensions. They file the policy, which is necessary to invoke appraisal anyway. All of these things are designed to freeze the lawsuit, not push it forward. So what this really boils down to is we look at the inventory of cases where there has been a finding of waiver and has not been a finding of waiver. And I think a fair reading of those cases puts this case in the non-waiver category.
Counsel, how long had this case been pending before State Farm raised its appraisal rights?
7 months, but Judge, that's a little misleading because there was an extension of time and then there's the motion for more definite statement. But and as Your Honor knows, there are often long time gaps when you file a motion and then you can get it heard. That there was a 3.5 month gap there, and the judge actually granted the motion for more definite statement, saying yes, give them more information. There was another almost 7-week lag before the amended complaint came, and then the amended complaint came, and then the motion for the appraisal was invoked. And I think it's also important that the cases on waiver don't talk about the amount of time. In fact, they affirmatively say that it's not the amount of time that passes, it's not how many pieces of paper are filed. Did the party invoking appraisal do something inconsistent with appraisal? And the things that none of the things that State Farm has done has been cited in any of the cases as being a waiver of appraisal. Notices of appearance, they're not things that push the litigation forward. They were all things to freeze the litigation until they could get a more definite statement. And when they got the more definite statement, they invoked appraisal. The things that
and to clarify the timing on that, Cam, you filed your motion regarding the appraisal within 1 month or less than a month, it looks like, of the amended complaint being filed.
Yes.
Okay.
I believe so. I've got the timeline here, Judge. Yes.
September 17th and then October 15th.
October 15th, right. And there was a request for an extension of time. So really, when you look at the criteria that the courts have used, including this court for waivers of appraisal, it's always things like filing motions for summary judgment, sending out a lot of discovery, setting cases for trial. And if you do the inventory of all the cases, including the case, the Cypress case that I was involved in just about a couple of months ago, those are the kinds of things. Protracted litigation, aggressive, proactive litigation. In many of the cases, it's the party that filed the lawsuit has been deemed to waive appraisal. In the non-waiver cases, sure.
If I could ask a question, once the trial court denied your motion to stay discovery, as I understand it, your client didn't seek any discovery. You only responded to discovery. Is that correct?
That is correct, Your Honor. That is correct. Now we filed, and that's a good point, because we had no choice. I mean, when the motion to stay was denied, we have no choice but to answer the discovery, or we could suffer sanctions or contempt of court. We're not going to do that. And those kinds of things are not proactive. They're following the rules of court as we must, and preserving, just in case we have to litigate, we have to preserve those things. But State Farm did nothing to advance the litigation. When you look at the non-waiver cases, this is a pretty typical non-waiver case. There's a delay. And in fact, several of the non-waiver cases, there was a little bit of discovery. And a couple of them in Branco, I think there was actually the parties filed a request for admissions, and there's some minor discovery that's been done. But in this case, State Farm did no discovery, none whatsoever. So this is the kind of case that really also dovetails with Florida public policy on these kinds of things. What State Farm did is looked at the original complaint and thought, what is the most efficient way to resolve this? Is this something very small that we can take care of in cross motions for summary judgment, or is it something that needs to go to appraisal? They sought that information, and as soon as they had that information, they sought appraisal. What's the public policy behind all of this law? The efficient resolution of claims. If it's something that it's more efficiently handled in appraisal should resolve it, and the courts lean toward that and try to achieve that result. If it's something that can be handled easily, then State Farm, it would make sense to keep it in court. So we believe that when you look at the spectrum of cases, there's a pretty bright line between the waiver and non-waiver cases, and this case falls within the non-waiver category. And I'll reserve the rest of my time, Your Honor.
Thank you, counsel.
Yeah, may it please the court. Mark Nation again. Thank you. I want to pick up right where Mr. Samus left off. The public policy in Florida is actually the opposite of what he just said. The statute on the mediation 6277015 in the introduction sets forth the public policy in Florida. And it says specifically that appraisal is, quote, potentially expensive and time-consuming adversarial appraisal process. And so it deals with the appraisal process and requires this mediation notice to go out. And if it doesn't go out, they waive appraisal. Let me say, contrast what they should have done with what they did. So what they did, and some of the stuff they did is right. They made their claim determination timely. And then 8/15/18, council said 19, but it was 18. 8/15/18, they make their claim decision. They send out the notice under 627-7015 that can only be sent out if there is a dispute. And the letter itself notes that there is a dispute between the parties. It says, as we discussed on 8/15/18, this part is not covered. And so they know that the pipes themselves are not covered. Nobody's ever made a claim for the pipes themselves in this case anyway. Anyway, they sent out their notice letter for the mediation properly and timely. In it, they say, they quote the Florida Administrative Code on this issue and say the parties have 21 days from the date of this notice to resolve the dispute before a mediation hearing can be scheduled. So there's 21 days after this claim determination for the parties to get together and try to resolve any dispute that they have. If they do, great. If they don't, then you can request the mediation, or State Farm or the insured can request appraisal at that point because there is a dispute. It's clear there's a dispute. They could have done that. And the council rightfully says they had the right to request appraisal at that time. But then State Farm's position in this case is, well, we had to figure out, what was being claimed because some of it may or may not be covered.
Well, what was the dispute at that time? When you say there was a dispute at that time, what was the dispute?
Yes, sir. There are three things that could be at issue and that were at issue. The amount of the water damage itself to the home, that amount's in dispute.
Well, how did State Farm know that was in dispute at that point?
Well, they say in their letter that we have a dispute. They've made a payment letter and they specifically say they've got this dispute and the claim is for the water damage. The other thing is, and they mention it here, the other thing in their claim letter is tear out of the home, parts of the home necessary to access the plumbing system. So those two things, they didn't pay anything for that. And then the cost of the pipes. Nobody's claiming the cost of the pipes. Those are not covered. They address that in the first sentence of their letter. But even if there is a coverage dispute, State Farm's appraisal clause is quite unique and it deals with it. And it says that goes to appraisal. Their whole position in this case is we had to wait to see exactly what was at issue, because if there were coverage issues, then we needed to have that resolved in litigation. But their appraisal clause in the third sentence of the appraisal clause, unlike most carriers, says this: if a dispute exists regarding the extent of the damages or whether any part of the loss is covered by the policy, the appraisers will itemize the damages according to the scope of loss specified by each party. In other words, their whole claim here is we didn't know if they were insureds were claiming part that was covered, part that wasn't covered, and we need to do litigation to figure that out. That's not accurate. Their appraisal clause says that that issue is an appraisable issue and should be addressed in appraisal. And they could have done it and should have done it after that 21-day period is up. They chose not to, all right? Then a lawsuit is filed. Instead of filing a motion to stay, a motion to compel appraisal, which we see all the time, and they could have done that and said, hey, wait a minute, whether it's dispute over the water damage, tear out, or the pipes, that's appraisable, especially under our unique appraisal clause, where we have an itemized appraisal form so that those things can be determined later. They should have asked for appraisal at that time. What that would have looked like is just move for appraisal at that time. Say, look, we've got this appraisal clause. There is a dispute. Here's our particularized itemized form, which sets out a line item for water damage, a line item for tear out, and a line item for pipes. If the appraisers award something for pipes, then we all know that's not covered and that wouldn't be paid. And that's why their particular appraisal form, they acted inconsistent with it. It's not that they acted inconsistent with appraisal. They acted specifically inconsistent with the particular appraisal clause that they have in their policy, and they didn't do it at the beginning when the lawsuit was filed.
Counsel, how did the trial judge address that issue?
The trial judge ultimately said that there was pleadings and motions that had filed and that had been waived. And when
No, I'm only focusing upon what you just told us, that the appraisal clause in State Farm says such and such, and they should have followed their appraisal clause. What did the trial judge rule on that argument that you made there?
he did not mention that at all. He just said that they had acted inconsistent with it by filing pleadings and motions.
Was that argument made to the trial judge?
The bringing up in this particular sentence, I did not see that in the transcript.
Okay, so that's something you've raised on appeal?
Yes, but it is a de novo, obviously a de novo review, and it may be, he had the right reason. This is another right reason for the right result. The clause itself is very explicit that those coverage issues are subject to appraisal.
Counsel, what pleading did State Farm file prior to responding to your amended complaint?
So pleading is, you're using that word specifically, and the first pleading they filed was their response to the amended complaint I believe. They filed some motions, but the case law says by filing motions or pleadings or acting inconsistently with appraisal. They could have saved 14 months of total time from the time there was a claim decision to the point where they finally asked for appraisal. They could have saved that by simply following the very simple procedure of waiting the 21 days and then invoking appraisal, or filing it right after the lawsuit is filed, motion to compel appraisal and stay the case, and avoided 6.5 months of litigation. At this point, they've waived it. They had multiple opportunities throughout. They could have sent a letter. They could have picked up the phone and said, hey, if really what the issue was, we don't know what this is about. They do. It's in their letter. If that's the issue, there were lots of alternatives for them to do other than litigating.
Do you agree the question is whether or not there was a voluntary and intentional relinquishment or conduct which suggests a voluntary and intentional relinquishment of the right to appraisal?
Yes, sir. And I think we're here today. And Mr. Samus is a good friend of mine, and I respect him greatly. And but I think he set forth this inconsistent conduct by listing out the things that they did that were inconsistent with their appraisal clause. And in the initial brief, in the reply brief, they say, look, we just needed to find out what was being requested. And then we decide, no, they knew what was being requested. They knew there was a dispute, and they knew their particular appraisal clause addressed all of that.
So the very first filing to the amended complaint is a motion to compel appraisal.
Yes, sir. And if they'd have done that to the original complaint, and mind you, nothing changed. The amended complaint, when we look at the amended complaint versus the original complaint, there's nothing different. There are words that are different, but not in any.
Well, those words might be important, right? Yeah. To the extent that they explain what the actual claim is.
What I'm saying is there's no meaningful difference. And here's the difference. It's paragraph 5 of the amended complaint. And it was added that the loss and damage was throughout plaintiff's home and known at the time of the loss. And it includes, but is not limited to, flooring, subflooring, foundation, slab, grade fill, laundry, subflooring, drywall, as well as the cost of tearing out and replacing any part of the home necessary to replace the failed plumbing system, and any other losses and damage that may have occurred. There is no meaningful difference. That is a very broad statement of what is being sought in this case. There's no meaningful difference between that paragraph 5 and the original paragraph 5. They're both broad, and it provides them no cover in their argument that, oh, now we know exactly what's in dispute. Now we can request appraisal. And by the way, they answered the complaint and they denied that allegation. They denied the allegation.
Counsel, is it your position though, that by filing a motion for a more definite statement in response to the complaint, State Farm waived its appraisal rights in this case?
In this particular case, yes, because they could have easily, well, first of all, their appraisal clause itself says that appraisal deals with both covered and non-covered items. So they didn't need the more definite statement. I agree that if somebody files a complaint and you immediately you file a motion, I think the first thing they should have done is filed a motion to stay and compel appraisal, because their appraisal clause applies to this situation, whether it's the covered water damage and tear out or the excluded pipes. Just have an itemized form. That's what it says to do. But if they were to respond instead and say, hey, we need a more definite statement, and then we'll figure out appraisal. And then there was an amendment that was meaningful and had something in it that provided them with some guidance, then that might be a right case to say, no, that's not actively litigating or taking a position that's inconsistent with appraisal. That's not what happened here. There was no meaningful change between the two, between the original complaint and the amended complaint. But more importantly, they should have asked for appraisal before suit was ever filed. There was a 6-month gap. They did everything right up until the point that 21 days expired for mediation. At that point, if they wanted appraisal, they had 6 months to ask for appraisal. We filed suit. They had the opportunity then to file a motion to stay and compel appraisal. They didn't. They asked for extensions. They got more extensions. They responded to discovery. In the hearing on the motion to stay discovery, they never mentioned appraisal in that hearing. They never said, we need to stay this because we're trying to figure out if this is an appraisable issue. Taking up the court's time in that is inconsistent with applying this appraisal clause in this case. Unless the court has questions, that's all I have, gentlemen.
Thank you, counsel. Samus, the floor is yours.
Thank you, Your Honor. First, with regard to the argument that somehow that State Farm's policy has unique language that changes and makes it all the case law on waiver inapplicable, that's just not the case. It's the standard appraisal language that you see all the time. There was never an argument that there was something unique about State Farm's appraisal language. This is an appraisable case. There is a difference between the initial complaint. I invite the court's attention to it. Said you breached by not paying enough. Mr. Nation read most of the new paragraph that gave a laundry list of all these claims. This is exactly what we needed to know if this is something that is more efficiently dealt with appraisal. It described a laundry list of things that they needed more money for laundry room, grade, fill, foundation, slab, tear out, and a couple of other things. Additional living expenses, law and ordinance damages. That's why the amended complaint made it clear that this was an appropriate case for appraisal. This idea that you have to invoke appraisal before suit is filed is just contrary to the case law. There's case after case after case in the briefs where there is a delay after suit is filed. The question before this court today is, did State Farm do something that waived its appraisal right, that was a knowing and voluntary relinquishment of the appraisal right? And that just doesn't appear in the record. The initial motion for a more definite statement, it cites the appraisal provision. It's in there. That was in the motion that was at that first hearing. Everything else was utterly passive. There is nothing in the record that has ever been pointed to by any of the district courts of appeal or the Florida Supreme Court that happened in this case that any of those courts have said, well, that triggers, that's something that is contrary to the right to appraisal. And finally, on the public policy point, the DFS mediation makes State Farm's point. The DFS mediation statute says you have to send the DFS mediation notice first, and then you wait, because if you can resolve something on a non-adversarial basis, you give it a chance. But what does the DFS mediation statute say? It says, if you send that notice, then you have preserved your right to appraisal. So State Farm preserved their right to appraisal in the DFS mediation notice, in its motion for more definite statement. And then when the trial court said, yes, you need to give a more definite statement, and it revealed the true scope of the complaint, State Farm filed its motion to stay and compel appraisal. That's consistent with this court's decision to Courtney Meadows, the inventory of cases that we've cited, and Florida public policy. And for that reason, we ask the court reverse and allow this case to be resolved by appraisal and not by unnecessary litigation.
And thank you, counsel, for your respectful oral arguments this afternoon. This concludes our oral arguments in this case.
Well, Chief Judge, Judge Lewis, if I could have a point of privilege, I would like to make a statement. Congratulations on 20 years of service on this court. And more importantly,
There you go.
Thank you, thank you, thank you, thank you. Much appreciated.
you bet. Congratulations.
With that said, this concludes our oral arguments this afternoon.
Thank
Have
you.
a great
all.
day.
Thank you,
Stay
judges.
safe. Thank you.